Hi, everyone. We're going to get started today. My name is Kristen Cranbeer. I am the Advocacy Program Coordinator for the ARC of East Central Iowa, located in Cedar Rapids. And I just want to say thank you all for joining us today. We are going to leave the last 15 minutes of this presentation open for questions, so please utilize that chat option at the bottom of your screen. We want to honor and respect everyone's time, and we will have a hard stop at 1 p.m. today. To help make your viewing easier today, please go to that top right-hand corner of your screen and switch your view to active speaker only. This is going to allow you the opportunity to see that full PowerPoint presentation. Frank sends out an information letter each year, and if any of you are interested in receiving that information, please email Frank at frank@disabilityplanning.org. This afternoon, our special guest speaker is Frank Varvaris. Frank is the proprietor of a firm in Cedar Rapids that provides planning assistance to people with disabilities and their families. He has been working in this field since 1990, and his office supports clients from all over the state who contact him for help. I will be sending a link for this recording and any handout Frank provides for this event in the next few days. This information will give you a clearer picture of who Frank is and the kind of professional work that he provides individuals with disabilities and their families. Today, he is going to present his workshop presentation on applying for SSI and SSDI. Frank has been a part of the ARC for 30 years. He is a past board president, and he has also served on our foundation board. In addition, Frank has served on Early Childhood Council, Iowa Brain Injury Council, Iowa Statewide Independent Living Council, Discovery Living, and more. Frank wrote the law in Iowa about special needs trusts for people with disabilities. He's a valuable resource, and I know that you'll find his information helpful. It is with great pleasure that I introduce our guest speaker, Frank Varvaris.
Thank you very much for that kind introduction. It's great to be back here hosting the educational series. Last month, we talked about the estate planning and the proper ways to create an estate plan for a person who has a disability. Today, I've been invited back to present Social Security disability, the process, and I want to be able to share that with the attendees so they have a better understanding of what is entailed in the Social Security disability process. My office also does the estate planning. We do Medicaid spend down strategies. We help clients apply for SSI and SSDI, as I mentioned. My office is an approved ticket to work employment network. So if I win a case for a client and they want to get back into the workforce, we know how to go about that. And I know what the rules are regarding income and how that would affect their SSI and SSDI income benefits. We have a subsidiary called Life Planning Administrators, which manages special needs trusts for clients. And we do a number of other things, including people that are in nursing homes. We do crisis planning in order to help protect the assets in the estate. What I'm going to do today is fast forward this, and we'll talk about applying for Social Security disability. And this is going to be a rudimentary presentation. It's going to contain general information about the Social Security disability process. Here are the objectives. We want to explain the four-part Social Security entitlement, help you understand how Social Security determines if you are in fact disabled, when and how to apply for benefits, Social Security's 5 sequential steps in determining whether or not a person is in fact disabled, what to do if you're turned down, and how to proceed to each level. Let's start with a little information about Social Security entitlement. And if you attended the meeting last month, I touched on this slide to some extent. The Social Security entitlement was signed into law in 1935, and that entitlement way back then created Title II of the Social Security Act. And what that did is it created this trust that held sacred money for wage earners that worked and paid into the system, with the idea that once that wage earner reached age 65, he or she could apply for retirement benefits. There is a component that goes with the Social Security entitlement, Title II, called Medicare, Title 18. And this was signed into law in 1965 by President Johnson during the Vietnam conflict. There is another component called Supplemental Security Income, SSI, Title 16. Now, my office is right across the hall from the Cedar Rapids Transition Center. There are a lot of young adults in there that don't have an earnings record, but have a disability that Social Security would approve for payment. But because they have not worked and paid into the system to create the work credits for Title II and Title 16, they are able to receive a different flow of income from supplemental security income, which currently pays a monthly payment of $841 per month, which I'll show you in a minute. If a person receives any supplemental security income in Iowa, we're a 1634 state, they automatically receive Medicaid Title 19 benefits, which are very important for a person who is an individual who has a disability. The maximum Social Security disability benefit that a person can receive is $3,345 per month. The maximum SSI is $841 per month. The catch is, in order to get benefits with SSI and Medicaid, because these are programs based on assistance for need, they're means tested. In general terms, a person can have no more than $2,000 in resources. An individual covered under Social Security entitlement Title II, they can have all the money in the world, and as long as they're found disabled and they paid into the system, they're still going to get their benefit package. When and how to apply. Let's share some important terms first. Social Security defines a disability as the inability of a person to produce what they call substantial gainful activity. And substantial gainful activity really means that they cannot earn more than $1,350 gross income per month in any occupation in the national economy. In 2023, that income level will increase to $1,470 per month. In 2021, the substantial gainful activity level was $1,310. Now, if an individual is self-employed, Social Security not only looks at their ability to earn the $1,350, but they look at number of hours the person could work. And if they can work 80 hours per month, even though they're not earning $1,350, they're not disabled. Substantial gainful activity for an individual who is blind is increased. Their threshold limit is $2,260 per month. A person should apply for benefits when they've been out of work due to a disability for 12 months, or number two, you presently are working but expect to have your disability conditions last at least 12 months, but you're earning less than $1,350 per month. Or if your medical condition is expected to result in death. Examples of that would be end-stage renal, kidney failure, ALS. Those would be typical examples of an individual that would be able to apply and get benefits quickly. If you are age 18, you should contact Social Security in the month following your 18th birthday to begin the process. And this establishes what we call the protective filing date. And the protective filing date is actually the date that you are protected. So when we begin the process of applying for benefits for SSI, then if the case is won, they will go back to your protective filing date as the onset date for disability. And you should do this if you are an individual already receiving benefits prior to age 18, because once you reach age 18, then Social Security will require another application must be filed for consideration as an adult. You should do this as soon as possible to expedite the consideration process. And I recommend clients contact the office if they want to do it on their own. At Cedar Rapids, there's the number listed: Coralville, Dubuque, Davenport, Waterloo. You can apply online. Some clients find that a little awkward and cumbersome, and they have a tendency to get overwhelmed. The phone interview might be the best, but I would recommend not calling the national number. Call directly to the office that is in the jurisdiction that handles the cases, the claims in this area. Cedar Rapids, for instance, would cover Lynn County. How does Social Security determine if I'm disabled? Well, they use 5 sequential steps to determine if a person is in fact disabled. The first step is they ask, are you working? The best answer is no. If you are working and earning more than $1,350 per month, which is the substantial gainful activity, then everything stops there. You're not disabled. There are a couple ways to get around that, but typically that's the end result. If in fact you are not working, or you're working and earning less than $1,350, Social Security will want to know, are your conditions severe? Have they lasted 12 months or expected to last 12 months or longer, end in death, and do they affect your basic work activities? And basic work activities would be walking, sitting, standing, lifting, carrying, stooping, grasping, bending, concentrating, learning, remembering, following instructions, getting along with others, including co-workers, supervisors. If they are severe, they go on to the next stage. Now, I am including a note here. Medical providers routinely will write a letter stating that this individual is disabled because they're applying for benefits. And according to the medical provider, they should be awarded benefits. Social Security does not necessarily put a lot of weight on those letters because everybody seems to get one of those letters and submit it to Social Security. It's the sequential steps that Social Security goes through and their examiners look at, and their judges also determine whether or not the person is in fact disabled. So the next question is, are you working? Number one, you're not. Then we go on to the next one. Are they severe? Number two, yes. So thirdly, are your conditions on Social Security's list of actual impairment? Social Security has what's called the Blue Book. The Blue Book lists all of these different impairments that are known to mankind that a person can have. If it is listed, then it's actually a bona fide impairment that Social Security will look at seriously. Let me share this with you. When I started this 25 years ago, helping people apply for benefits, Asperger's was not on Social Security's list of actual impairment. So it was really difficult to win a case for a person with Asperger's because there was no listing. Well, that subsequently changed, and Asperger's is now a listing that was encompassed with the broad autism spectrum disorder. But back in the early days, it was difficult to get benefits for a person that had Asperger's. The next, number 4, is can you do previous work? So if you are a person that did work and you've got a work history, can you go back and do previous work? And the best answer is no, you cannot do that. And then lastly, this is the catch-all. Can you do any work based on your education, experience, age, so on and so forth, any work in the national economy? And those can be jobs like watering a plant, folding laundry towels, shredding paper, running a photocopier, jobs that may not be extremely meaningful for some people, but because there is a job in Montana, and you could do that job according to Social Security's determination, and you could earn $1,350 per month, you're not disabled. So again, here are the phone numbers clients can contact. Let's talk about the interview. What will happen next? During an initial interview, Social Security will want your name, address, Social Security number, where you were born. That's identifying information. They may ask for your birth or baptismal certificates. Social Security will ask for your bank account numbers, routing numbers, etc. They will ask the names, addresses, phone numbers of your doctors, clinics, hospitals, therapists, caseworkers, local AEA if you've been to them and you've got a file, VR file if you have a file at the VR, that have seen you and when. They want to know the date. They will want to know the future medical appointments that you will have in the future and the approximate dates. Social Security will ask for a list of your medications, any lab tests that you've had, the results of those tests and the dates. They may ask about your work for the last 15 years. The initial phone interview usually takes about 60 minutes. The claims representative wants to get it done and put behind them. Online, trying to do it yourself can take much longer. Social Security prefers people to do it online, but they are really charged with the responsibility to assist with the interview and the beginning of the application process by doing it over the phone. Now, after the interview, your application and file material will be sent to a determination service called the DDS. That's the Disability Determination Service, which is in Des Moines. It's actually housed in the voc rehab office. The Disability Determination Service will appoint an examiner to review the claim and file information, and then write to your doctors and the other entities that you've seen and given information to the claims rep over your initial interview so that they can learn more about your condition. The Disability Determination Service will ask questions like, what are your medical conditions? When did they begin? How do they limit your activities? What your doctor's medical tests have shown? What treatment you've received? Any information regarding IEP, regarding special ed material? As Social Security may also ask about your ability to do work-related activities. And those work-related activities that I've mentioned previously is the walking, sitting, standing, lifting, carrying, stooping, grasping, et cetera, to see if there are transferable skills that you can use to look at other jobs. Oftentimes, the disability determination examiner does not have adequate information to make a proper decision. So they will order out what's called a consultative examination. The abbreviation is CE. And Social Security will pay for that exam by a medical provider that they choose in order to get more information about your medical condition. And these consultative examinations can be either mental, a psych eval, or physical eval, or they can do a combination of both. I normally talk with clients prior to them going to the consultative examination because I want them to understand there is no doctor-patient relationship. The practitioner that is meeting with you is being paid by Social Security to do an impartial evaluation to look at the severity of your impairments. And so it's important to expose those impairments to the treating physician to make sure they understand that you do have serious impairments that affect your health. Finally, the determination service examiner will organize your application and file material, and they will give it to a committee of professionals such as doctors, therapists, vocational experts, who will review all of the medical information in your claim, and they will make a decision. The disability determination will send you a letter notifying you of their decision. If you are awarded benefits, they will begin following the month and paid retroactively back to your protected filing date for SSI only. If you're awarded Social Security Disability Income, SSDI, Your back payment will be calculated and generated by the Baltimore SSA office and paid retroactively to what's called the proven onset date of disability, and they can go back as far as 1 year in order to create a back payment. If you are denied benefits, on the other hand, then the letter will state that you can request reconsideration. If you are awarded the SSI monthly benefit, it's important that your countable resources are less than $2,000, as I had shown on that slide previously. If you have more than $2,000, you will not qualify for SSI monthly payments. Countable resources include cash you have, money you have in checking and savings, investments, CDs, a second car, cash value of life insurance if the death benefit is over $1,500, money in an IRA, 401k, etc. Social Security will add all of these up together. And if you are over $2,000 in resources, you will not qualify. So it's important as you go through this process that you know how to reposition the assets in your estate if you're over $2,000, so that if and when your case is won, you're going to get your monthly payments and you're not going to lose the benefit because of a resource violation. If you are denied benefits, then it is because Social Security thinks you can work in some kind of a job and earn the substantial gainful activity, which is $1,350 per month. You have 60 days from the date of the denial letter to complete a request for reconsideration. In other words, we're going to appeal this because we do not agree with the denial that you gave to this client. So we are going to submit a reconsideration form and accompanying forms that Social Security also needs in order to take it to the next level. When you file your appeal, the claim will be sent back to the Disability Determination Service for review again. The DDS examiner will request that you furnish any new information and records that you have regarding your disability, and they'll want you to provide current treatment dates again. You must also complete and submit another form called the 3441BK appeal and an adult function report, 3373. What does that mean? Well, the 3373 is what do you do from the time you get up in the morning until you go to bed? What activities do you do? Do you do volunteer work? Do you have an animal? Do you feed the animal? Do you let the animal in and out? Do you go for walks with your animal? All of these questions that could create a red flag, I think it's important for the individual to know how to fill these out fully and carefully so that we can not create a lot of red flags as we go through the process. At the DDS, a new committee of professionals will review the claim again the second time, and they'll make another decision. They will send you another letter notifying you of their decision. This usually takes anywhere from 90 days to 120 days for them to make that decision. If you are awarded benefits for SSI or SSDI, or if you are awarded the benefits in a combination, congratulations. If you are denied, then you have the right to request a hearing with an administrative law judge. If you receive a letter denying benefits at the reconsideration stage, which is the second level, you have 60 days to complete a request for a hearing form, notifying Social Security that you are appealing their denial because you disagree with their decision. And when you see this, the sequential steps of going through this process, a lot of clients are unable to complete all these forms. So what happens is they become overwhelmed and they give up in the process. It's important to have some type of an advocate or representative help them so that your claim can move from one stage to the next, even after going through the denial. You've got to keep moving forward. If you quit and reapply, then you're starting all over again, and you may run out of insurability under the Title II entitlement, and you could lose a lot of benefits. We also would need to complete the Form 3441BK, which is the appeal form that needs to be submitted. At the hearing level, and it can take 12 to 18 months or longer to get a hearing schedule, so you need to hang in there. At this stage, your claimant has the best chance of winning because they have an opportunity to provide testimony to the judge and explain why their disability conditions impede their ability to work and earn SGA. At the initial application level, which can take 3 to 6 months for a decision, 70% of applicants are turned down. This is national. Reconsideration level, which can take another 3 to 6 months for a decision, 85% are turned down. So what does that mean? It means that Social Security doesn't necessarily embrace people and provide benefits early on for them. They make them work for it. Retirees, on the other hand, they are embraced by Social Security because that's actually the reason why the entitlement began. Retirees get their benefits automatically. People with disabilities have to prove that they are in fact disabled and unable to earn an income at a certain level. At the hearing level, which I had mentioned can take 12 to 18 months for a hearing, and then it can take 3 to 6 months after the hearing for the judge to finalize the 12-page letter of decision. Nationally, 55% win. In Iowa, 48% win. Now, if you look at the 55%, you have agencies that advertise nationally, and some of them do it on TV in the wee hours of the morning where clients may not be able to fall asleep, and they'll see this advertisement on TV. It'll be a national office that takes on all of these disability clients, and then they fly out to meet with the administrative law judge and handle the hearing with the client. I've actually seen some of these people fly in to Cedar Rapids at the Cedar Rapids local office with their suitcase, and they'll introduce themselves. Hi, I'm so-and-so. I'm the individual that's going to be representing you. They've never met this person before or had very little contact, but they know they've got a 55% chance of winning. So they're going to make a lot of money. Facts to consider. A final decision can take up to 2 years or even longer. And if your case goes in front of a judge, here you have the best chance of winning, as I mentioned before. Many people become overwhelmed. I don't want that to happen with clients. Hiring an appointed representative to assist can be very beneficial and improve your chances of winning. Representatives are typically paid 25% of the retroactive back payments for their work to a maximum of $6,000. So I had a case that I won for a client. I was able to win the case based on her deceased father's earnings record. She was in her early 50s. I was able to go back to prove to the court prior to age 22, she was disabled. So she won children's benefits based on her dad's level or earnings record. She got a $300,000 back payment. Excuse me. I was entitled to 25% of that to a maximum of $6,000. She paid me $6,000 for my work. These are things that will blow a case. If the client will not get medical care for their condition, they don't go to the doctor, they think everything's going to be fine. So we don't have any medical records to substantiate the severity of their claim. The individual doesn't keep the representative up to date. They move around, they don't have their phone working, they never get back to the representative, responding to emails or texts. They miss deadlines. Perhaps Social Security created one of those exams, the consultative exam for an individual, and they don't go. That's a big no-no. The client uses drugs or alcohol, they abuse them. That'll kill a case. And then lastly, if they break the law or end up in jail, that really will significantly impact adversely a case for benefits. Okay, that is my overall. That we went through that in short order here. Are there questions from the audience?
Thank you, Frank. Yeah, we've had a couple come in. The first one is, so let's say, for example, you have been diagnosed with extreme migraines. It makes it difficult for you to be able to work and perform your regular tasks. Do you have the possibility of being able to get SSI or SSDI?
Absolutely.
Okay.
Yeah.
That's good to know. And then everyone was asking, would it be possible, and I've gotten a few messages on this now, is there any way that when we send the recording out to everyone in a few days, could we also include your actual PowerPoint with that? Would you be able to share that with everyone who's here today?
Good question. That's kind of proprietary.
Okay.
And I run the risk of having representatives and use this for their own benefit. Let me think about that if I
Okay.
may.
Yeah.
Thank you.
I think that's reasonable. Okay, so we'll get back to you, and those of you who have asked for it, if we are able, then we will provide it, and if not, it's understanding that Frank has put a lot of time and energy and work into this. Our next question: can a parent get SSI for their child if their parents have more than $2,000 in assets?
That's a good question. Normally, it's $3,000 for the parents, but if the child is over age 18, no problem. because the child stands on their own. It's an adult now, 18 and over. So they only look at the resources and income of that adult child turning age 18. Prior to age 18, then it's tricky because Social Security will look at household income and resources. And normally there are limits, and usually the child will not qualify.
Okay. Our next question, is it still best to get a legal representative involved after being initially denied? Or what's the best time to actually get a legal representative involved?
I'd say to do it from the beginning. Because what that does is it gives you an opportunity to create a relationship, and you're building the file, the record together. The forms that would take the case to the next level, you might put down some red flag words that could be detrimental to your claim. But if a person's able to do it on their own and that's what they want to do, they have every right to do so. But I think representation is probably extremely beneficial for most claimants.
Let me see. Next question that we have, if the retro payment is over 2,000, how will this affect the 2,000 threshold?
Okay, that would be with the SSI, and it could also be with SSDI. So there's two things. SSI states that a person can have no more than $2,000 in resources. Okay, they get a back payment of $10,000. Does that count against them? No. For 9 months, it does not count. It's exempt. However, beginning in the 10th month of receipt of that money, it's a countable resource. So we need to do something with that money in order to continue monthly payments. And what would we do? We might look at repositioning part of it in an Enable account. We might look at it some other things. We might buy things for the individual that they need in order to spend it down appropriately so that we get back down below the $2,000 level. If it is SSDI, then you can have all the money in the world, like the Rockefellers and the Kennedys, you're still going to get your monthly payment. However, Medicaid will look at it, and unless you are on what's called MEPD, Medicaid for Employed People with Disabilities, you're limited to $2,000 in general terms. We would need to do something with that money. And what would be some things we would do? We could look at the ABLE account. We can convert the asset to supplement your monthly SSDI payment. We can spend it. We can put together a different strategies in order to enhance your life.
Perfect.
And answer
Oh, no, go ahead, Frank. Sorry.
no, did that answer the? Hopefully that answered your question.
Yeah, I think that did a good job of that. Next question we have is, do earnings below the $1,350 monthly reduce the SSI amount received?
Yes, they do. SSI will be reduced after $85. Half of the earned income that a person receives gross from work will be deducted from the SSI payment.
Our next question is, could you clarify that you said it's quicker not to do this online? And it says, I believe the SOAR program teaches that online expedites the process.
I know. And that is true. I mean, if somebody wants to do it online, I've had clients that started it and then they end up calling me and they said, well, I can't figure this out. And so then we'll have them sign forms, we'll access the website and continue it, but if we hadn't gotten involved, they might not have been able to finish the application. So I believe the phone interview is the best.
It says for a minor disability child, does parent needs to pay from the parent's paycheck for child to get the SSN benefits in the future?
Could you repeat that? I want to make sure I understand that, please.
Yep. So if you have a minor child who's diagnosed with a disability, does the
Right?
parent need to pay from the parent's paycheck for that child to get benefits in the future?
No. No, there would be no cost to the parents. No.
Okay. Is there a certain trial period for people to attempt to work before losing benefits?
Yes, there is. There's actually two. The first one, a person goes back to work. Social Security encourages people to go back to work and give it a try. Maybe you can become self-sufficient. So they have what's called the trial work period. And the trial work period gives an individual with a disability going back to work, whether it's SSI or SSDI, an opportunity to have 9 months of earnings that could be unlimited. However, every month they earn over $970, 970 or more, they use up 1 month. And if, in fact, they've done that for 9 months, and it doesn't have to be consecutive months, over a 5-year pull, 60 months, then they enter into what's called the extended period of eligibility. And in those months, if an individual earns substantial gainful activity, which currently is $1,350, they don't, if they're SSDI recipient, they don't get a check. If they are an SSDI beneficiary or SSI beneficiary, excuse me, they will still get some money, but it is reduced according to their Social Security's formula. Excuse me. And at the end of a 36-month continuum where they've had 36 months of earnings over SGA, they will lose their benefits. But they will still maintain eligibility for Medicare, healthcare coverages, and then they reserve the opportunity, if they cannot hold the job, they will go back on the benefits through what's called an expedited reinstatement. So the short answer is people can go back and earn, and they are protected through these programs, through the Ticket to Work. And there's 2 stages, the trial work period and the extended period of eligibility.
Wonderful. Thank you, Frank. Next question we have, where can someone get assistance in getting their appeal paperwork completed?
Well, we do that, but they could probably call attorneys. Sometimes caseworkers with various agencies will help. But typically you should find a representative that will take the case and complete the forms for you.
Next question we have is, if someone loses SSI benefits due to the 7-year rule and hasn't gotten citizenship yet, do they need to reapply for SSI after they become a citizen?
It's a good question. I don't know the answer to that. I would have to research it. I don't know.
Okay, so I would say maybe I'm the person that asked that question. It might be a good idea to send you an email so that they can
Sure.
connect with you to get the answer to that.
I can find the answer definitely for you. I'm happy to
Perfect.
do that.
Our next question that we have, if an individual has money in a 401k with the idea that they will not cash it out or have access to it until retirement age, and it's over $2,000, will they automatically be denied?
For SSI, yes. For SSDI, it's no big deal.
Okay. Next question we have, when a client gets inheritance, how long do you have to spend it?
That's a good question. We are a date of death state. And what that means is, and I'll have clients that call in, Uncle Bob died, left John $50,000. And the attorneys want to get this done. We want to know what we can do in order to protect benefits for John and still have that money available. Well, theoretically, John got their son got the money when the uncle passed away, because we are a date of death state. However, based on the luck of the draw, whoever the income maintenance worker is with the state, they may say, well, they haven't gotten the money yet, no problem. But once they get it, then they're going to lose benefits in the month that they receive it. And then it should be spent down prior to the first moment of the first day of the next month. If it's not, they'll lose Medicaid and related services. They will also lose SSI too.
Okay,
So
that's good to know.
once they receive it.
Our next question is, in what situation would someone be awarded preemptive SSI benefits, and how would they continue to receive benefits ongoing?
Repeat that one more time, would you, Kristen, please?
Yep. In what situation would someone be awarded preemptive SSI benefits, and how would they continue to receive those benefits ongoing?
Okay, good question. If the individual, and are we talking SSI?
I'm going to presume so in this situation.
And is it presumptive disability?
Yep.
Or it's presumed that there is a disability?
Yes.
Yeah, then they've already got the shoe in and they've made a decision where that person's been found disabled immediately. It could be ALS, it could be end-stage renal disease. There could be a number of other things that Social Security approves, and then they would continue getting their payments. But they still will have eventually a CDR to see if there's been any changes in the person's health status 3 to 7 years out.
Okay. Our next question. My husband is retired and plans to start taking SSI in January. The representative told him our daughter needs to apply for SSDI to begin at the same time. She is 22 years old and has never worked or received SSI benefits. How is the $2,000 max resource affected? Must the bank account the money will go into be in her name, or can it go into an account under her parents' name?
Okay. Well, she's applying for a benefit based on her father's earnings record because she's under the age of 22. And so that would continue if she's found disabled. The person that manages the money, that's the representative payee. If she's able to manage the money herself, it would go into her account. If, on the other hand, Social Security determines that she's unable or incapable of managing that money herself, then they would appoint a representative payee, who typically will be a parent or another agency, but typically it's a parent, and then the parent establishes an account at the bank with a letter from Social Security showing that they are the payee, and the monies would be directed to that payee account.
Perfect. Okay, next question. Is it more difficult for someone to be approved for mental health, disability, versus physical?
It can be, yes. Yep. Sometimes, yes. Yes.
Next question. If I have been a court appointed as legal guardian upon my son's 18th birthday, when I help him apply for SSI, is all financial information based off of my son's resources?
Yes. Only because the son's 18 years old.
Do children living with a legal guardian qualify for SSI?
Good question. Yes.
Frank, I included your information again into the chat for everyone. But how long does it take to get an appointment with you?
Well, we try to be as quick as we can. What I've been doing is I typically have been having phone conferences with clients to get the ball rolling forward, or a Zoom meeting. I'll do either one, and probably maybe a week to 2 weeks out.
Okay, so not too far.
Not too bad.
Does the person need to fill out the daily activities in the 3373 BK form themselves, or can someone else, such as a representative, fill this out for them?
They can, but it's best to have the client at least take a shot at it.
Okay,
And then I'll take it after that, and I'll expose in the remarks section, the client was unable to understand these questions, could not fill this out. Their penmanship is terrible, and so I am completing the remainder, and the person, the client, was unable to answer these questions, so I had to consult with their parents in order to get the accurate information. So what I want to do is build this case as much as I can and use that to show that the client couldn't even fill this out.
okay,
Can't answer the questions.
okay. If a person loses disability under a review that determines they are no longer disabled, is there assistance to get help during that appeal process?
Yes, we've done that, and yes, there is.
Okay, wonderful. Oh, okay, and sorry, I misread that. So when we were originally talking about that 22-year-old daughter, the husband is not taking out SSI, he is just taking out Social Security. And it's been recommended that the daughter, who is 22, go through that process. So this is, instead of dad taking out SSI, it's just Social Security. Okay,
that's what I thought you probably meant. See, in 1956, the government changed, Congress approved an amendment to Title II Social Security Act that opened up a window of opportunity for dependents of a wage earner to maintain benefits under the wage earner's earnings record. And one is, it opened up, if you are a wage earner and you have children, a disabled child under the age of 18, they're going to get benefits, roughly 50% of the wage earner's retirement payment. And it doesn't reduce the wage earner's retirement payment. The child gets 50%, and then they apply for disability when they reach prior age 22. They get the continuum of that, and they will get that for life, unless they marry. If they marry, they're no longer dependent, and they don't get that benefit.
Okay. Oh, I know we were going to do a hard stop at 1 o'clock, but there are a few more questions. So I want to respect anybody's time that needs to go to another
Sure.
meeting. But maybe we'll just take a few more minutes and just answer a couple more of the questions, if that's okay, Frank.
Yes,
So one of our questions is, do you take clients from all over Iowa or just specifically to Eastern Iowa?
all over. As a matter of fact, I've had one cases for clients in Michigan, Minnesota, Florida. So it can be, but
So all over.
But it's right. Right.
Is there a fee payment for your assistance?
Only if I win the case. And then it's 25% of the applicable back payment to a maximum of $6,000.
Last question that we have, and then I want to follow back to something we talked about before we even started recording. So this question is, I work with adults with chronic mental illness, often the ones who need to apply for disability the most are the least able to navigate this process themselves. Are you comfortable working with clients like this who may be displaying significant symptoms?
Yes, but I would prefer, if possible, that an advocate join us, or a caseworker, or a social worker, somebody also join us so that they can re-explain to the person what it is that we're doing.
Okay. And then what we talked about before we even started today, when we were just chatting at the beginning, can you walk someone through the process really quickly? Because we see this a lot in our field, that we will have families who will come to us and say, I can't afford guardianship and I don't know what to do. I've gone to multiple attorneys. They can't provide me the support that I need, and I can't afford this. What are their options through SSI?
Great question. I tell families, if you're going to apply, petition the court or have an attorney create a guardianship for your son or daughter, let's start simultaneously the SSI application for your child. And then tell the attorney, we're applying for benefits under Title 16, the SSI Supplemental Security Income Payment. And we'd like to use that money to pay your legal expenses. Is that acceptable? And normally, it is. The SSI payment is typically used first for shelter, food, medical care, to make sure the individual's in a safe environment. But anything left over from that can be used for legal work and other things, recreation, So I tell parents, well, let's go ahead and simultaneously begin the SSI process. And in the meantime, you talk with the attorney and let him or her know that we're doing this and that you would like to proceed with the guardianship. And we'll use that money once the case is won to pay for the cost.
Perfect. Thank you for kind of breaking that down for us, Frank. And thank you for coming today and providing this presentation. I know how much we all appreciate it. Again, just for those who didn't come in at the beginning, this is going to be recorded. So we're going to be sharing this recording with you all. And that way you can have access to it. And if need be, please feel free to share that with your community. But Frank would be more than happy to meet with you or any of the individuals that you serve and their families, just to help provide support in any way that he can. So thank you so much. We appreciate it. And we hope that you have a great rest of your day.
Great. Always a pleasure to work with you, Kristen. Thank you.
You too, Frank. Thanks.
Take care.